Ladies and gentlemen, welcome to this video. This video is going to be looking at the 1983 House of Lords judgment in the case of the Crown and Miller. We're looking at it in the legal context of actus reus within criminal law, and specifically using the case to answer the question of whether a person can be guilty in an actus reus sense of an omission to act. We know that ordinarily a positive act, coupled with the requisite mens rea, will be sufficient to amount to culpability. But here we're examining the question, well, what if there's not a positive act, but merely an omission to do something, i.e. the offender does not do something? Now, I should say from the outset that we're exploring this in the context of criminal damage, and the question that we're answering would not be answered yes in the case of all offences, because we know that not all offences could be committed by omission. And for example, if you look at the case of Fagan and the Metropolitan Police Commissioner, which is also on this website, you will see there that the court says that the offences of assault and battery are not capable of being committed by omission. But if we look at the present case, which does concern criminal damage, here we have an appellant, Miller. He was a vagrant who was living in an unoccupied property. He came home one evening and lit a cigarette, lay down on his mattress and fell asleep before he had finished the cigarette. The cigarette fell from his mouth or his hand, whichever, I'm not entirely sure, but it fell from his possession and set alight the mattress on which he was sleeping. Now, when he awoke, he saw that the mattress was smouldering. Now, despite what you or I might think we would do in those circumstances, Miller's reaction was merely to move to another room in the house. And as you can imagine, therefore, the bedroom caught fire and a substantial amount of damage was caused to the property. Now, Miller was charged with arson, contrary to Section 1 of the Criminal Damage Act. And this section makes it an offence to, without lawful excuse, destroy or damage property belonging to another, intending to destroy or damage any such property, or being reckless as to whether such property be destroyed. And that's simple criminal damage. But if the damage or destruction is caused by fire, then it becomes arson, contrary to the section. Now, Miller's appeal made it all the way to the Court of Appeal and was dismissed. But at the Court of Appeal, they identified a question of law of general public importance. And this is a key phrase for our general understanding in relation to how appeals are generated. Because it's only for this reason that the Court of Appeal refer the case to the House of Lords. They don't refer every case to the House of Lords. But here, because there was an issue of law that was of general, wider public importance, they referred it up to the House of Lords. Now, this is useful for us because when we look at the judgment, we can see specifically the question that the court is asked to consider. And also, that question, therefore, will be the centre of my analysis and should be the centre of any analysis that you conduct into a House of Lords judgment, particularly if you're writing a case note on the judgment. Now, the certified question is at page 174 of the judgment and reads as follows. The question the House of Lords were asked was whether the actus reus of the offence of arson is present when a defendant accidentally starts a fire and thereafter, intending to destroy or damage property belonging to another, or being reckless, and it's reckless that will be important for us, as to whether any such property will be destroyed or damaged, fails to take any steps to extinguish the fire or prevent damage to such property by that fire. So you can see there's an omission element written into the question. The short answer was yes, they can be liable. Now what we need to do here is to go through and see how the House of Lords reached that conclusion. Now, the House of Lords was unanimous in giving a yes to that question, and it was Lord Diplock that delivered the single judgment in the case. And as he did so, he began by saying that the old-fashioned Latin phrases of actus reus and mens rea were not the most useful here, particularly in relation to offences created by statute, which of course arson and criminal damage are. Now, he said in this context he would prefer to speak of the conduct of the accused on the one hand and his state of mind on the other. And clearly you might think that conduct is wider than just a positive action and might itself include an omission to act. Now, if we look at the case, the first question that any jury would have had to have asked was, of course, one of causation, itself an actus reus element of the crime. So the question, did a physical act of the accused start the fire that caused the damage? And it's an important question in relation to criminal damage and arson, because these are effect crimes. Something happens as a result of the action. Now, in this regard, the answer was clearly yes, it was his cigarette, the dropping of it, that caused the damage. But then, having done so, in terms of the conduct of the accused, the jury then need to go on to consider not only the acts that caused the fire, but also any failing on the part of the defendant to take measures that lie within his power to counteract that danger. And we'll have a look in a minute as to why they need to consider that, but that's clearly the omission aspect. If they do find that conduct element of the offence established, then of course they must ask themselves whether one of the requisite states of mind, the mens rea aspect, is also present, namely intention or recklessness. Now, of course, in this case, it's clearly recklessness, because Miller didn't intend to burn down the building or cause damage to it. And as we know from Fagin, the actus reus and the mens rea must coincide. So we're looking for a state of mind that coincides with an actus reus element. But what the court is saying is this actus reus element can be wider than just the positive act that caused the fire to start. It can be this later conduct aspect of omitting to do anything to ameliorate the danger caused. And if that coincides with recklessness or intention, then you have a complete offence. The similarity with Fagin is that in both cases, Miller and Fagin, the initial act is accidental. In Fagin, it's driving the car onto the policeman's foot and setting alight the mattress in the case of Miller. And therefore, there can't be any mens rea at the time of this particular inadvertence. So the question in both cases becomes whether there is any later actus reus type aspect that could be in existence when the mens rea is formed. And in Fagin, as they decided that an assault could not be committed by omission, they relied on a continuing act theory. That is, that the presence of the car on the policeman's foot was itself a continuing act. And when Fagin decided deliberately to leave the car on the policeman's foot, then he formed the mens rea at the time when the actus reus was continuing to take effect. Now, the court considered the continuing act theory advanced in Fagin, and they also considered a duty theory that had been advanced in the writings of Professor Smith and had been referred to in argument in the case. And Lord Diplock preferred this duty theory, and he did this on the basis that it would be easier to explain to juries and easier for them to understand. And in effect, we don't have a duty to correct all wrongs that we witness, but we do have a duty to act if we are the ones that actually create the risk of the damage in the first place, if we cause the risk of the damage. So if I see a house on fire, whilst I might have a moral duty to cause the fire brigade, I'm under no legal duty to do so, and if I don't, I'm not guilty of an offence because I lack an actus reus aspect. But if I have caused that house to become alight, then the law imposes a duty upon me to take steps, such as calling the fire brigade, in order to ameliorate that risk. And what Lord Diplock said, that he advised judges to direct juries that an accused would be guilty if, quote, when he becomes aware that the events in question have happened as a result of his own act, he does not try to prevent or reduce the risk of damage by his own efforts, or if necessary, by sending for help from the fire brigade. And then the reason why he does not is because he is reckless or intends the damage. Therefore, that's the mens rea element being tagged on at the end. Now, this case is specifically only concerned with criminal damage and arson, but it could have a much more wider application, subject to it not applying to those offences that are incapable of being committed by omission, such as assault and battery. So that's the Miller case. I should add one footnote to it, and that is, in the case of Miller, they look at the mens rea of criminal damage, and they use the out-of-date version of recklessness. That is the objective version that was put forward in the case of Caldwell. We know now from the case of G that recklessness is subjective. And if you want to look at the case of G, it's either explained here already or will be in the near future. And there are a number of G cases, and it's the 2003 case that you need to look at. But suffice to say that despite the fact that it's using what is now an outdated form of mens rea, that's not what is important for the Miller case. The Miller case is looking at actus reus and deciding that the actus reus element can be established by omission where there is a duty to act. And that particular conclusion remains a valid one at the time that I make this video.